All right, everyone. So welcome to our AP U.S. Government Live Review. This is Must Know Supreme Court Cases Part 1. If you guys have any questions during this entire live review, feel free to ask the question in the little Ask a Question tab on the bottom. I get like a notification if you ask a question there, so it's easier for me to look at those rather than if you put them in the chat. But feel free to put them in the chat as well. I'll try to look back at that once in a while. So yeah, let's get started. As always, remember to follow Fiveable on Twitter, Instagram, and YouTube. We're coming out with a really big announcement tomorrow, so be sure you are subscribed to us so that you can get all of the latest updates. Again, follow us on all of these platforms so that you can get more information about this. So this is our weekly stream schedule. If you want to take a picture of it, this is just for the rest of the week. So Mondays, AP Lang and AP Stats. Tuesdays, Human Geo, Psych, and Gov, which is this. Then tomorrow, Wednesday, it's APES. Then we have Physics, and then Bio. And then on Thursdays, we have our history classes. So if you ever need anything, be sure to follow Fiveable on social media, and you'll probably be able to find it there. So just a little bit about myself. My name is Akhilesh, and I'm a junior from North Carolina. I really love politics. I like learning about politics, current events. And I took AP Gov as a sophomore last year. I'm a junior this year. I got a 5 on the exam, and I'm really excited to share this stuff about government and politics with you guys through Fiveable. So a little bit of a stream schedule that's more specific to AP Government. We'll have part 2 of this stream, which is with Ms. Powell next week on Must Know Supreme Court Cases Part 2. So we're going to do half of them today and half of them next week because there's 15 required cases that you have to know for your AP Gov exam. So I'm going to do 8 and Ms. Powell is going to do 7 next week. Then the week after, I'll be back for a review of public policy, specifically social policy. Then again, throughout March, we do a little bit more policy streams with economic policy. And then we end the month going through the 14th Amendment. And then by April and May, we'll start going back to the other units to review for the AP exam. So like I said, there are 15 required Supreme Court cases that you need to know for the AP exam. The ones that we're going to talk about today involve the First Amendment and selective incorporation. So there are 5 with the First Amendment: Engel versus Vitale, Wisconsin versus Yoder, Tinker versus Des Moines, New York Times Company versus the U.S., and Schenck versus the United States. And then there's 3 with selective incorporation: Gideon versus Wainwright, Roe versus Wade, and McDonald versus Chicago. So if you guys want to take a picture of this, that would be great. Before I go any further, I just wanted to ask, can everyone hear me? If you just like type something in the chat, if you can, that would be great. All right, so I see Sandra, Brayson, and Lance are on. If you guys could just say something, if you can hear me, so that I know I'm not just talking to myself. Okay, I'm gonna go ahead and get started, but if you can't hear me at any point during the stream, please let me know so that I can check all the technical stuff. Okay, so the first thing we're going to talk about is why do we need to know them? So on your AP exam in May, your third free response question is a Supreme Court comparison case. Basically, what that means is that you'll be required to compare one of the 15 required cases with a case that's presented to you on the exam. So the case that's presented to you on the exam, they'll give you like a paragraph or paragraphs of information about the case, and then you will have to use your knowledge of one of the required cases to compare it to the one that's on the exam. So it's really important that you know all 15 of these in and out. These required cases are also the ones that tend to appear throughout the AP exam multiple choice. Before AP Gov was redesigned, they didn't really have like a specified list of cases. So like there were a bunch of cases that could possibly appear on the exam. However, now that they put out this list, it's very likely that the exam questions on the multiple choice would align with these cases, and that is the case. So please make sure you're familiar with all of them. it's essential, again, that you analyze these cases in depth so that you are prepared for the AP exam. So one thing that I would suggest is just each week focusing on a case. There's like about 14 weeks left before the exam. Try and get those in so that by May, you can just review all 15 of those cases and you are good to go. So these are the things that College Board says you are required to know for each case. You need to know a short summary of the case, just something where you're able to introduce your essay or introduce your free response with a summary of the case. Then you should understand the constitutional issue. Often part A or part B of that free response question is going to ask you, like, what constitutional clause is common between this non-required case and Brown versus Board? And then you'll have to understand what constitutional clause goes with Brown versus Board so that you're able to write about it. And then you're going to be required to know the holding, constitutional principle, and majority opinion. Even if you don't know, like, it was a 5-4 decision, you don't really need to know anything that in depth. You still do need to know, however, that it's like it was either like who like it favored, who the ruling favored, just so that you're able to write about it. Again, the main point is that if you know all of these cases in and out, you will really be able to succeed on that free response question. And that free response question is often, some people say it's the hardest, but if you really know your cases, that one should be one of the easiest. So hopefully through this stream, you're able to gain a little bit more knowledge about those cases. So I kind of already talked about these, but this is kind of the layout of the free response question. Again, identifying that common constitutional concept, describing relevant facts, explaining similarities and differences, and then explaining the interaction between basically what they prompt you to talk about and the case. So just learning those cases really well is going to help you do well on the exam. So the first thing we're going to talk about are the cases involving the First Amendment. So like I said before, what I like to do with all of my cases and all of my presentations is refer back to the College Board's context and see exactly what they want you to know. So this is like the exact wording that they have in their syllabus with all of the cases that relate to the First Amendment. So provisions of the U.S. Constitution's Bill of Rights are continually being interpreted to balance the power of the government and the civil liberties of individuals. So if anyone wants to respond in the chat, what are civil liberties? I'll wait a few seconds and then we'll keep going. But if you know anything about civil liberties, civil rights, feel free to put that in the chat. Okay, so civil liberties are freedoms that are guaranteed to us by the Constitution to protect us from tyranny. The difference between civil liberties and civil rights are that civil rights are kind of protecting people from discrimination, whereas civil liberties are like the freedoms that are in the Constitution. So like the ones in the First Amendment, like you might have learned rights, religion, assembly, press, positioning the government, speech, all of those are civil liberties, okay? So let's talk about the first case. So the first case is Engel versus Vitale. So if you are taking notes on this or watching this replay after, just kind of divide your paper into like 8 sections because we'll be taking notes about or looking over 8 cases from the AP exam. So to start out our First Amendment cases, Engel versus Vitale. So a summary of this case, basically this occurred in New York. So the New York Board of Regents, which is basically like their school board, authorized that at the beginning of every day, a non-denominational prayer was to be recited. So that was kind of required. Students could opt out of it if they wanted. However, there was a prayer that was held. So several organizations filed a lawsuit against the Board of Regents, and they said that the prayer violated the Constitution. So in your First Amendment, you have 2 clauses that relate to religion, the Establishment Clause, the Free Exercise Clause. So in this case, the Establishment Clause was what was at stake. So even though the prayer was both voluntary and non-denominational, people said that because it was happening in a public school, that was unconstitutional and it went against the Establishment Clause. I talked about this. And the Establishment Clause, literally like exactly what it says, is that a law cannot be made that respects a law could not be made respecting an establishment of religion. Okay. So yeah, like it's just saying that government, basically they can't endorse a religion and say, this is the religion of the United States. Because it was happening in a public school, that was like the main issue revolving around this case. What happened with that case, the holding and constitutional principle, basically the court said that the states could not hold prayer in public schools. They said even if it was voluntary, even if it didn't adhere to a particular religion, even if it was non-denominational, they could not hold prayer in school. This was because, like I've emphasized, this is happening in a public school. An act of prayer is considered a religious activity, and that kind of shows that the government is endorsing religion, even if it was not a specific religion. So that's made, that was what was made very clear with this case. And yeah, I've said the public school thing several times, but it's super important to know these details so that you can connect you can connect and make like a good paragraph just about this case. Okay, so if you guys in the chat, just summarize Engel versus Vitale in one sentence or phrase, if you can. So just based on like what we covered with that, how could you summarize Engel versus Vitale in like one sentence? Yep, freedom of religion. Anything else? All right, good job, Camilla. Exactly. Freedom of religion. That's exactly what this revolves around. Basically, school sponsorship of religious activity is a violation of the First Amendment. Okay, so if you know that concept, you will be able to succeed on the AP exam and connect it to your non-required case. The clause that this relates to, again, is the Establishment Clause. So just remember, a public school cannot hold religious activities, and because that violates the Establishment Clause, okay? The next case we're going to talk about is Wisconsin versus Yoder. So Wisconsin versus Yoder, personally, I think it's one of the most interesting cases that are covered within these required cases for the AP exam. So it took place in 1972, and basically just a short summary, a person named Jonas Yoder and other people that were Amish, so that's where this background comes from, they refused to send their kids to school past the 8th grade. So they said that their kids were not going to go to school, and that because their religion did not agree with high school attendance. That was kind of a part of their culture, and they felt that the government should not force their kids to go to school because it went against their religion. However, the parents were charged under a law that required the students to attend school until age 16. If you think about now, like truancy laws, all of those things often charge the parents if the child decides to drop out of school before the age of 16. So they were charged under a similar law because children were required to attend high school at that point, or at that time. The constitutional issue here was that it relates to the other major religious clause of the First Amendment. So does anyone know what the other clause is? We talked about Establishment Clause. Does anyone know the other one? So the other First Amendment clause that deals with religion is called the Free Exercise Clause, okay? So remember, with the First Amendment, what I like to call it is like just like fee wraps is what we were taught. So like FE, that stood for free exercise. The second E stood for establishment, and then your wrap stood for those other rights that are listed. So just make sure you remember that the two clauses are the Establishment Clause and the Free Exercise Clause. So this case did relate to the Free Exercise Clause, and what the question was by requiring these parents to send their children to school without an exception for faith, did it violate their right of free exercise? Because the parents were practicing their religion, they felt that because their religion or culture mandated that students should not attend school past the 8th grade, they felt that they didn't have to because that was their free exercise of religion. However, the question is the government interest in kids attending school more powerful than the personal religious interest of those parents? So what the holding and constitutional principle is that the court held that the requirement to send children to school beyond 8th grade was unconstitutional. So they said it was like you couldn't force the parents to send the kids to school past 8th grade because the individual interest in free exercise is more powerful than the government interest in sending kids to school beyond 8th grade. So just remember that. That's kind of like our short, like little one phrase for this case. The individual interest in free exercise is more powerful than the government interest in sending kids to school. So that just kind of reinforces the First Amendment. So we'll see several cases that reinforce the First Amendment, several cases that take back from the First Amendment, limit our rights, our First Amendment rights. So that's kind of another way that you can categorize and help you remember. So both of the ones that we've done so far propelled our First Amendment rights, but this one is limiting it, or some other ones will limit it. So just remember that. Okay, does anyone have any questions so far with Engel versus Vitale or Wisconsin versus Yoder? All right, so let's keep going. If you guys could, in the chat, what Amendment 1 clause does Engel versus Vitale relate to? And what about Wisconsin versus Yoder? So just which one does each of them go with? We both know, or we all know that they both go with freedom of religion, but we talked about those two clauses in the First Amendment. So which one is Engel versus Vitale, and which one is Wisconsin versus Yoder? Yes, Engel versus Vitale relates to the Establishment Clause, and Wisconsin versus Yoder relates to the Free Exercise Clause. Great job, Dakota. All right, so so the next case we're going to talk about is Tinker versus Des Moines. This happened a few years prior to Wisconsin versus Yoder in 1969. One thing that I do want to remind you guys or emphasize is that you don't need to know like these exact dates. I know some teachers require you to like memorize the years and stuff where these cases happen. It's helpful to know the general time in which they happen to contextualize. So like for your AP World, AP Euro, a push class, you know, like with your DBQ or your LEQ, you're required to have contextualization. Something like this with the date kind of helps contextualize your essay and can help just you contextualize the time that was in, maybe draw some parallels when you are talking about that case. So with this case, this one's a little bit more famous. You've probably heard of it. This one relates to the free speech rights of kids in school. So a group of students decided to wear black armbands to protest the Vietnam War. These two students were Mary Beth Tinker, who is like the one in the case, and Christopher Eckhart. Basically, they wore these armbands despite the warnings from school administration that they could be kicked out if they wore those bands. But after wearing those armbands, they were sent home. So once the school saw that these kids had those armbands at school, they decided that that was not acceptable, that it was a disruption to the school environment, and they sent them home. The constitutional issue here is that the students decided to sue the school district for violating their freedom of expression. What the constitutional question is that kind of revolves around this case is, did the prohibition against wearing the armbands, which is symbolic speech, violate the freedom of speech clause? So does anyone know what like symbolic speech is? Like an example of symbolic speech? Flag burning? Yeah. So any of these things where like it's not like you are physically like talking and that's how you're giving like your speech, like it's not literally like speech, like talking speech, with flag burning or like wearing armbands, doing other forms of protest that are obviously expressing your opinion. However, they're not like you literally talking. So in this case, the armbands that are protesting against the Vietnam War were the symbolic speech type things. The holding and constitutional principle in this case, the Supreme Court ruled that students have free speech rights at school. To justify the suppression of speech, they said that it has to substantially interfere with school operations. Does anyone know the case Bethel School District versus Fraser, I believe? Have you guys heard of it? All right, so that case, it was like I think it was in a high school. Like the kid, he went up and he was like running for class president, something like that, student government, and he went up and he gave like a speech that was filled with like double entendres. Like it was filled with like things that had double meanings. It was like could be interpreted as really inappropriate. In that case, the kid did get suspended, and after he got suspended, he was like later he later like sued the Supreme Court and stuff, or sued the Supreme Court. He sued the school district for suspending him. But in that case, the Supreme Court said that like that speech, which was like vulgar, it had a vulgar meaning, that could definitely be something for, like, they could restrict that because that was disrupting the school environment. In this case, because the armbands did not substantially interfere with school operations, they could not restrict that speech. So that's kind of the difference. In the other case, it was like the kid giving a vulgar speech where, like, I mean, it was inappropriate, and that was like inappropriate for the school environment. In this case, nothing is happening where like there's like clear like discord or anything among students. It's just that they're just expressing their opinion. So that's kind of the difference between those two cases. So there is a question: would this include private schools with uniforms and such? No. So that's one thing to remember. Public versus private schools. Public schools are funded by the federal government. Okay, that is the main reason why all of these cases relate to public schools. With public schools, because they're funded by the government, anything that the school does, any rules that it enforces, those can all like kind of like, you can point fingers at the federal government for that just because the federal government is funding it. That's why with like that first case with Engel versus Vitale, they ruled against the school district because they could not, like, it was not allowed for that prayer to be conducted since the school district is representing the federal government and the federal government can't endorse a religion. So private schools and uniforms, anything really that a private school does not like really matter to the federal government because the federal government isn't funding it, and therefore the federal government, like, you can't draw a straight line from the federal government to that private school. Does that make sense, Camilla? All right, thank you. Again, if you guys have any questions during this entire stream, feel free to do just what Camilla did. Click the Ask a Question tab on the bottom, and you can just ask a question, and then I'll be able to clearly see it. So to continue talking about Tinker versus Des Moines, they said that the right of symbolic speech was more powerful than the potential disorder that it could cause. So because it was not anything that was inherently causing any kind of disorder, they said that it could be allowed. This is a phrase that you'll commonly hear, that students don't shed their rights at the schoolhouse gate. What that basically means is that students do have rights. A lot of times what we hear in the news and current events is that students are being oppressed in school, or they're like dress coded, and people feel like that's not a appropriate, like, you know, that's going against their freedom of expression. However, with the Supreme Court case rulings, it has been made clear that students don't shed all of their rights at the schoolhouse gates. However, because at school you are like technically under the school's like watch, it's like in loco parentis or something like that. There's a Latin word for that. Basically what that means is that the school and the administration and stuff, they serve as your parent there. So that's why they can like take your phone, search it, stuff like that, just because they serve as your parents there, and it could be important to the safety of the school. So at school, you do have less rights, you could say. They're not as open as you would outside of school. However, you do still have those free speech rights, like the symbolic speech stuff at school. So that's kind of something just to remember if you ever see this phrase. That came from the majority opinion of Tinker versus Des Moines. Okay, so anyone have any questions about Tinker versus Des Moines? All right, so we're going to move into New York Times Company versus the United States. So this case had to do with the Pentagon Papers. So it's known as the Pentagon Papers case. Basically what happened is that the Nixon administration tried to prevent the New York Times from publishing specific material. Basically what they said was that it would be like, it would go against, like, it would be a detriment to national security. What the Pentagon Papers were a Defense Department study about U.S. intervention in Vietnam, whether it was really necessary, that kind of like a cost benefit analysis kind of thing. Nixon said, like I said, it was necessary to national security to prohibit it before publication. Does anyone know what that's called when the federal government tries to restrict something from going into the press? Okay, so what that's called is prior restraint. So this case focused on prior restraint. If you ever see that wording, just know, like on your AP exam, just know that that relates to this case. Okay. Right, it's right there. Okay, so right down there at the bottom, you can see that's the New York Times article headline when this case was like finally resolved. The New York Times was the one that like was publishing this, and that's why it really generated national attention. Obviously, it's like the New York Times, a huge newspaper, kind of a key staple in many people's households. So that's why it generated all that attention. So the constitutional issue here was if Nixon's administration's if like their administration's prior restraint, so them like saying no, we're not going to release it if that was constitutional because of our like free speech, free press, all of those rights. And if that was a violation of the First Amendment. So all of those like liberties that we talked about, especially the free speech, free press, and like in general, freedom of expression, those were the main things that people were debating, that there was a clear violation of that within what the Nixon administration did. With the holding and constitutional principle, the Supreme Court bolstered the freedom of press with this ruling. They said that even for national security purposes, there has to be a heavy presumption against prior restraint. So basically, like unless it's like an extreme case, you really can't withhold the press from publishing anything because that goes against our free press and free speech rights. That was kind of their opinion with this case. The only exceptions and main exceptions that you definitely want to know, this could be things that appear on your AP exam, are obscenity or immediate and direct dangers to national security. So if there is something where there's clearly obscene content in it, or there's something that there's like a direct and imminent threat to national security, if that is published, then obviously that cannot be published and prior restraint can be invoked. However, really other than that, there's no other exception to like not releasing a document or not like preventing a news company like the New York Times from publishing something like this. So what First Amendment clause or what's First Amendment like right did New York Times Company versus the United States relate to? So if you could just answer in the chat. Wait a few more seconds. Okay, so the clause that this went with, the part that it went with was freedom of the press. You could also argue freedom of speech. Really, though, the main thing is freedom of the press just because it was like the New York Times and they were the ones that published this. And then Nixon was like, no, you can't do that. So just remember that New York Times Company versus the United States, that goes with the Nixon administration and the Pentagon Papers case. Okay, so the next case, I believe this is the last one for First Amendment, then we'll move on into selective incorporation, is Schenck versus the United States. So in Schenck versus the United States, summary of it, during World War I, several socialists, including the namesake Schenck, distributed leaflets. So basically what these leaflets were saying was that the draft that was occurring during World War I, obviously we needed people to go fight. He said that this draft was violating the 13th Amendment. So the 13th Amendment actually prohibits indentured servitude. It prohibits slavery. Okay, so he wanted people to disobey the draft. And what happened as a result, with all these leaflets being passed out, and people like obviously they were going towards his cause, they were like, "Oh, I agree." He was charged with violating the Espionage Act of 1917, which it's like kind of like almost like you're trying to interfere with the war efforts. Like there could be something that you could be causing danger to our country. Okay. The constitutional issue here is that Schenck appealed on the grounds of the First Amendment. He said, hey, well, I had my First Amendment press rights, free press rights, my First Amendment free speech rights. Why can't I publish these leaflets? Like, why does it matter? So what was discussed within the case was whether the Espionage Act violated the First Amendment, and if like this like kind of restricting the distribution of these leaflets, charging Schenck under the Espionage Act, if that was an appropriate exercise of Congress's wartime authority. Like, could Congress do that in war, technically? So if you look at the left, that's actually like a political cartoon from then. Loose lips might sink ships. So some people felt that if you like people like Schenck were passing out these leaflets that were like, okay, don't go through the draft. Like that's that's basically slavery. Like our government are violating like one of our essential rights that we've had for so long. People would obviously not be inclined to go through the draft, and they would disobey the draft, which at the time, it was necessary for America to fight in the war, arguably. So a lot of people, these political cartoons, basically what they were saying is, if you just talk like this, they might like lose lips, might sink ships. Like there could be like dramatic consequences to this. So it's not possible. So the Supreme Court kind of agreed with this cause in their constitutional principle and holding. They said that the Espionage Act did not violate the First Amendment. What they said was that it was an appropriate exercise of Congress's wartime authority. This is a key limitation of the First Amendment. So you know how in the last one I kind of talked about how with Tinker versus Des Moines, how like our First Amendment rights were bolstered, like they were increased because there wasn't like really any disruption. And then with New York Times versus the United States, I talked about how like unless it was like really a threat to national security, you can't stop something from like going on or like going into the newspaper. With this one, this is a key limitation on the First Amendment. The Free Speech Clause does not allow for advocacy of unlawful behavior. So if you're advocating for illegal stuff, like something that clearly goes against the law, the Free Speech Clause does not allow for that. So you can't just break the law and then be like, okay, well, that's like under my free speech rights. It's kind of like if you, like the example that's always given is like you yell fire in a crowded theater. You can't just go in and do that because first of all, that's unlawful. It can create major discord and it's illegal. Like that's the main thing. Free speech does not protect stuff like that. So just remember, Schenck versus the United States is a limitation on the Free Speech Clause. New York Times versus the United States helps the Free Speech Clause. It gives us more free speech rights and free press rights. Okay, I didn't know that. I forgot this was the next question, but I kind of just answered it. Tinker versus Des Moines, that's another case. It strengthened free speech rights. Schenck versus the United States placed limitations on free speech rights. All right, so before we move into our next section, which is cases involving selective incorporation, does anyone have any questions about the First Amendment cases, anything that we've talked about so far? Feel free to put it in the chat in the Ask a Question tab. Anything works. Okay, so let's move into selective incorporation. So does anyone right off the bat know what selective incorporation is? Or an idea of selective incorporation? I did see that most of you guys are taking it year long, so I don't know, maybe you haven't gotten to it yet. That's a possibility. Selective incorporation, like the actual like definition of that, is that portions of the Bill of Rights have been made applicable to the states piecemeal. So piece by piece, we're making the Bill of Rights, which is like basically guaranteeing that the federal government provide us those rights. We're making that stuff applicable to the states piece by piece. So it's not like we're saying, okay, the entire 10 Bill of Rights, first 10 amendments are all going to be applied to the states. Okay, done. Case by case, piece by piece, we're incorporating these amendments. So like, as you can see, the ones we're going to talk about, they vary in time: 1963, 73, 2010. I think 2018, 2019, like 1 or 2 years ago, the Eighth Amendment, the cruel and unusual punishment, that part was incorporated. So this can like keep going on and on and on. So just kind of remember, selective incorporation is a theme that College Board loves. So be familiar with that. Like write that down, like to do more research or something. I would definitely recommend being familiar with selective incorporation. So the three cases that we're going to talk about are Gideon versus Wainwright, Roe versus Wade, and McDonald versus Chicago. So like I said before, we're going to first look at the College Board context. It says protections of the Bill of Rights have been selectively incorporated by way of the 14th Amendment's Due Process Clause to prevent state infringement of basic liberties. Okay. So the main thing that I want you guys to get from this is that selective incorporation always happens as a result of the 14th Amendment's Due Process Clause, okay? Does anyone know what the other clause in the 14th Amendment is other than due process? Often that's the one that's like more familiar, but does anyone know what the other one is other than due process? Yes, the Equal Protection Clause. So Equal Protection Clause, that's like the one that goes with Brown versus Board of Education. Any case that involves selective incorporation, if they ask you like what clause of the 14th Amendment goes with this, it has to be the due process clause. Okay, so please make sure you remember that. That's often one thing that like students get confused with. I remember last year on our AP exam, the free response question, it was a Brown versus Board Supreme Court question. So they specifically said, what clause of the 14th Amendment does this relate to? So Brown versus Board is not selective incorporation. That one's the one that relates to equal protection. And so like obviously you were required to write equal protection. When the scoring things came out, it clearly said on the scoring guidelines, if the student wrote due process clause of the 14th Amendment, even if they were right about the 14th Amendment part, but they said due process clause, they cannot be given credit for that part of the question. So just remember, any case that involves selective incorporation has to go with due process. Okay, that's just one thing that you're gonna have to like memorize. It's kind of a weird way, like why those two relate, but just remember selective incorporation cases. The three that we're gonna talk about here: Gideon, Roe, and McDonald. All three of those go with due process. Okay, so the first one we're going to talk about is Gideon versus Wainwright. That happened in 1963. This is an interesting, like to me, this is probably one of the most interesting cases. There's been like a documentary / movie type thing that's been released. It's old, but it's about Gideon versus Wainwright. It's actually really interesting, so I'd recommend you check that out. But Clarence Earl Gideon was charged in Florida State Court on a felony breaking and entering charge. During his trial, though, Gideon, he was of like a lower like class. He did not have too much money, so he requested that he received a court-appointed lawyer. In accordance with Florida state law, though, basically what the law said was indigent defendants or defendants that can't afford a lawyer, they could only have an attorney appointed in capital cases. So a capital case is a prosecution case for murder. So basically what the state court said was that if it's a state case, those defendants could only be appointed a lawyer if it was like they're being charged with murder or attempted murder, something like that. Okay, so yeah, that was just a law. Like Gideon really wanted like a lawyer for his state case. That was like a felony breaking and entering, because really he couldn't afford like the fine and what his sentence was going to be like that was given to him. So he really wanted a lawyer. However, he was not afforded one based on the previous state law. So the constitutional issue here involves the Sixth Amendment, and it's whether or not the right to counsel guaranteed in this amendment can apply to felony defendants in state court. So with Supreme Court, it's basically public defenders are there. So you will get a public defender if you cannot afford a lawyer at the Supreme Court. However, this one has to deal with the state court. So remember how I said selective incorporation is like piecing or like piece by piece. So we're trying to incorporate those federal protections to the states. So this one is trying to incorporate a Sixth Amendment protection, which was the right to counsel, to the state court, because Gideon did not have one, or Gideon could not get a lawyer since it was state court. If it was federal court, he could have. So that was kind of like the main reason why this was like a big deal. Basically, the Sixth Amendment right to counsel does apply to state court defendants via the 14th Amendment. That's what was decided by the Supreme Court at that time. This caused like a big, like rapid, like effect in the South, really throughout the country, because there were so many people that were put in jail without being like, they couldn't have a lawyer. So they had to defend for themselves. Obviously, you know, like a person that's indigent, like they can't afford a lawyer. They're probably like, they don't have that ability to defend for themselves. They're not a lawyer. They can't often defend themselves very well in court. So what the Supreme Court said was that the right of counsel, counsel is just another word for attorney or lawyer, is fundamental and therefore should be incorporated into states. So one thing you'll see with all of these cases that we talk about that have to do with selective incorporation, they say the right of blank is fundamental, and that's why they should be incorporated to the states. So the Supreme Court kind of has to find that as fundamental in order to selectively incorporate it through the due process clause. And yeah, so this part of the Bill of Rights now applies to states. Okay, so what amendment did Gideon versus Wainwright go to? So just quick answer in the chat if you can. Yes, the Sixth Amendment's protection up on the right to counsel. Okay, so let's keep going. Next case is Roe versus Wade. So Roe versus Wade, you've probably almost definitely heard of this case. It's like always like being debated, under controversy. However, this is a very significant landmark case in our history. So it's really important that you know all about it, regardless of whether you agree, disagree with the decision. A lot of these things, that's what you'll find with AP Gov. A lot of the things, like especially like some students, like they get very like political in their responses. To the free response questions, a lot of times it's better just to describe the processes rather than taking like a side or an opinion. So just make sure that's something that you're doing, like you don't take a side necessarily. Like you can use it as an example, but it's generally best if you present, especially Supreme Court cases, from an unbiased point of view, and you're providing just like the background, facts, summary, like what happened in the case. That's just something to remember. Okay, so with Roe versus Wade, so sorry, my PowerPoint was glitching, but Norma McCorvey, which is the person's real name, her real name, but she went by Jane Roe in the case. She wanted an abortion, but she could not legally have that abortion in Texas. So what happened was she decided to go to a neighboring state to have that abortion, and she felt that Texas law that prohibited abortions except in cases where the mother's life is in danger, she felt that violated her right to privacy. The legality of that law was what was questioned in this case. So she felt that the abortion, like the right to have an abortion, was a part of like a really broad right of privacy. Like none of the 10 amendments directly say all people shall have a right to privacy. However, within, I believe it's like, I think I have a list on the next slide. But the 1st, 4th, 5th, 9th, 14th, I believe, amendments, all of those kind of talk about, somehow relate to the right to privacy. So she that's where she questioned the legality of the law. And yeah. With the constitutional issue, in a previous case, so Griswold versus Connecticut, the court ruled that the Bill of Rights creates zones that establish the right to privacy. So like I said, amendments 1, 3, 4, and 9. So those zones were kind of like something that the Supreme Court tried to establish so that, I mean, they obviously can't go back and just like change the entire Bill of Rights, right? They can't just add like, okay, let's do a 10.2 amendment and like add the right to privacy. They felt that through Amendment 1, 3, 4, and 9, the right to privacy was pretty much implied through those amendments. That's what they decided in that previous case, Griswold versus Connecticut. Now they were deciding whether a woman's right to privacy or a woman's right to an abortion fit within the zones of privacy that were established with that previous case. So the holding constitutional principle, what it said was that the right to an abortion is within that implied right to privacy that was guaranteed by Griswold versus Connecticut. And it incorporated this fundamental right to the states, expanding the definition of privacy. Okay, so a lot of these cases, like I said before, it's really easy to categorize them into, did they strengthen our rights? Like, did they like add to our rights, or did they detract or limit our rights? It's a really easy way for you to make sure that you remember the content of these cases really well. Okay, so question for the chat. Roe versus Wade expanded the definition of the right to blank. Yes, privacy. So just remember, Roe versus Wade had to do with the broad right to privacy. The right to privacy is implied. It is not directly stated in the Constitution. However, because of Griswold versus Connecticut, which established those broad rights and broad zones of privacy, Roe versus Wade kind of expanded on that. Right. So our next case is McDonald versus Chicago. So McDonald versus Chicago is a really recent case, happened only about 10 years ago. Some facts for this case, Chicago had passed a handgun ban law, and several suits were filed against the city because previously there was a case in Washington, D.C., which was D.C. versus Heller. And what happened in that case was the court had held that a D.C. handgun ban violated Amendment 2. Well, now you might be thinking, okay, well, it already said that. So why did that case not just incorporate it to the states? However, because it was in D.C., that law had actually been enacted by the federal government there. So technically, that right, so like the Second Amendment right, had not been incorporated to the states yet. So another case through McDonald versus Chicago was necessary. And this was where like the suit was filed against the city of Chicago because people felt that, like I said before, the Second Amendment was a fundamental right. So the applicability of the Second Amendment to the states was argued, and if the Second Amendment's right to bear arms, interpreted as an individual right in DC versus Heller, also applied to the states. So again, like I said, selective incorporation is a theme that College Board loves on the AP Gov exam. Just make sure you remember that's why the reason why McDonald versus Chicago is a selective incorporation case is that in a previous case, a similar, like almost the exact same thing happened in Washington, D.C., where a gun ban was implemented and it was ruled unconstitutional. Here, they're trying to get it to apply to the states, the Second Amendment. Okay, so the holding and constitutional principle, the court stated that the handgun ban was unconstitutional. It was a tight decision, 5-4. And they said that since the right to self-defense was fundamental, the Second Amendment could be incorporated by the states. Key pattern here, again and again, if they determine that something is fundamental, that's how they can incorporate it to the states. That's kind of a key word that you'll see within almost every selective incorporation case, is that the right to blank is fundamental. And again, this is through the 14th Amendment's due process clause. So just a question for the chat to kind of summarize what we talked about with selective incorporation. What are like 2 or 3 things, common themes that you see with selective incorporation rulings? Like that's something that you see on a consistent basis. Just anything. Don't like feel pressured to reply, but just anything that you've noticed with those 3 cases that we did about selective incorporation. Okay, so that's okay. We will talk about it then, if I can get my PowerPoint to work. Okay, so it's always something specific from the Bill of Rights. So it's out of like amendments 1 through 10, and they are trying to expand those rights to the states. It needs to be interpreted as fundamental, and it's applied to the states because it's fundamental. And again, like I emphasized before, it's through the 14th Amendment's due process clause. So just remember, it's a fundamental right applying to the states through due process. All right, so that's all I have with the Supreme Court cases. This is just an overview of the AP Gov schedule for the next few weeks. We have the rest of the Supreme Court cases. Remember, you need to know 15. We did 8 today. 7 will be next week with Ms. Powell. Then we have review of public policy for the next 2 weeks. That's like the last unit of AP Gov. Then we kind of do some review streams going back to the 14th Amendment on March 17th. Again, if you want to take a picture of this is our weekly calendar for this week. The stream topics will change. However, the timings will not. I know they're kind of small, but Lang and Stats are Mondays, Human Geo, Psych, and Gov are Tuesdays, APES, Physics, Bio are Wednesdays, and then our histories are all on Thursdays. So just remember, if you have any questions about the stream schedule, feel free to reach out to anyone on Fiveable. Does anyone have any questions for me about anything that we talked about today? Yes, I can put the link to the PowerPoint. Just wait 1 second. Sorry, I know you guys are seeing this, but it's okay. All right, let me know if you can see the PowerPoint now. Do you guys see like a little green button on the bottom of your screen or no? It should be there now. It should say like presentation, and if you click on it, it should take you there. All right, so what is the most effective way? All right, thank you. What is the most effective way to study these Supreme Court cases? Okay, so the most effective way to study these Supreme Court cases, what I would do is I would make some kind of like index cards or T-charts, Quizlet, something like that, and put out, like write out those things that we just talked about. The constitutional issue, the holding, what happened in the case, and kind of like a summary or background. write those down on index cards or like on a piece of paper and make like a review chart for every single one of those 15 cases. I would recommend starting now, taking like one case and working on that like consistently for 3 or 4 days. Then put it like on Quizlet or something and then start working on another case. And as you go through that next week, make sure to review that first case too. So kind of if you keep doing that over and over again, you'll get the hang of it. A lot of these cases, like the First Amendment cases, are normally pretty easy to grasp. Those generally, if you can recognize, those are First Amendment cases. The writing won't be that bad. Generally, the ones that I had the most difficulty with were ones that will be covered next week: Baker versus Carr, Shaw versus Reno, and Citizens United versus the Federal Election Commission. Those three, for me, I felt were the most confusing. For those, I would start studying those now. So the ones that are the hardest for you, like just going through them, like I would say that the First Amendment ones are things that you could probably save for closer to the end, just because they're not as hard to grasp. Like they're not as hard to memorize the details, just because it's generally more simplistic than some of the other ones. Like Citizens United, in my opinion, is so complicated compared to some of these. But like just watching review videos, if you look up required AP Gov Supreme Court cases, Citizens United, you will find like 15 videos on YouTube with various teachers that have uploaded them. I would just keep watching those videos, taking notes, putting them on Quizlet. There are a bunch of Quizlets there out already, but I'm like, you'll probably learn better if you make one yourself, or just like making an index card, one of those bigger index cards, and like writing all this stuff out. It will definitely help you. The earlier you start with these cases, the better it will be for you. I would say the same thing with those foundational documents, like Federalist 10, 51, 78, and like Martin Luther King's letter from Birmingham jail, all of those that you're required to know. I would start doing that now too. Personally, I procrastinated and I waited like a week before the exam to start studying these, and trust me, it was not a good idea. So definitely do that. I have a semester class and we just covered U.S. versus Lopez. Could you just talk about this one? Because I struggled with this one. Okay, U.S. versus Lopez. Okay, I will pull up my slide for that actually, if I can, but I might not be able to. So U.S. versus Lopez was an interesting case that had to do with the Commerce Clause. Okay, so basically what happened was a kid. He was like he lived in Texas. He was charged with a law that basically said why do you have it was a firearm possession law, firearm possession law, and it said that you were not allowed to have firearms on school premises. However, this kid did carry a concealed weapon into his high school classroom. He was charged with violating a criminal statute, which was the Gun-Free School Zones Act, I believe, of 1990. Basically, what the act said was that you can't possess a firearm if you know it's a school zone. Like that's kind of what it said flat out. And then he was given like a hefty sentence, I think, that he felt was not appropriate for his cause. Congress had legislated this act through the Commerce Clause, which is kind of like if you look at the Commerce Clause, you'll see that Commerce Clause is something that the federal government kind of tends to grab onto, and that's how they make a ton of their laws, because what it says is that interstate commerce is regulated by the federal government. So they basically everything that goes from one state to another, like if you even trains that go from one part of the state to they go across the border to the other part of the state, that can be regulated by Congress somehow. Okay. With what Congress with what this case said, what it was saying was that the Congress was exceeding its power in legislating that act, that Gun-Free School Zones Act. It was going beyond its power that was given to it by the Commerce Clause. So it's kind of improper use of the Commerce Clause. What they were saying was the possession of a gun in that school zone is not going to have any substantial effect on interstate commerce. I think what Congress's reasoning in that case is because guns can go between from state to state or manufactured state to state. Congress had the authority to legislate that. However, having a gun in a school zone does not substantially have an impact on interstate commerce. Does that make sense? So because it does not have that direct impact on interstate commerce, it's the Congress was exceeding their bounds. Okay. And then that's why that act was deemed unconstitutional, and basically it went in Lopez's favor. Does that make sense? Do you have any other questions, anyone? Feel free to ask any questions you have about AP Gov, Fileable, even other AP classes that you might be struggling with. No problem. All right, so if that's it, thank you for coming. As always, remember to follow Fileable on Twitter, Instagram, and YouTube. Again, we have a really big announcement coming out tomorrow, so be sure to stay tuned to that. And again, if you have any questions, feel free to leave them in the chat now. If not, that is it for me. Thank you so much. Have a great night, everyone.